Dual intent visas. What are they? Why does it matter? And what are some strategies that you should potentially consider depending on whether your visa classification or your employee's visa classification is dual intent or not? That is what we're talking about today at Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you have joined us. Whether you are joining us live or catching the replay, I'm glad that you're here. If you have questions about this topic or another topic related to US immigration law, feel free to put those in the comments and I will address them if and as I can. So as I said, today we're talking about the topic of dual intent. So what does it mean if a visa classification is dual intent? It refers to this idea that a person can hold a non-immigrant visa classification, which is also called a temporary visa classification, and pursue permanent residence at the same time. This is amazing for those visa classifications that are dual intent because it means that a foreign national can hold that particular visa classification, and we'll talk in just a minute about which ones those are, but a person can hold that temporary visa classification and also pursue the green card. That means that they can make plans to stay here in the United States long term. Their employer can sponsor them for the employment-based green card process, and the person can extend their status here in the United States and be able to travel internationally without having to worry about the fact that they have the green card process in place. Now, this topic is more nuanced than we will be able to get into today. So know, of course, that this is not legal advice. This is for informational purposes only, as always. But know that there are some strategies that you need to consider, and wait to the end. At the end, we're going to give a few key takeaways to take away from this, to keep in mind, to take away from this video, from this summary. But know that one important thing to know, one important concept is even if your visa classification or your employee's visa classification is not dual intent, that does not mean that you or your employee cannot start the green card process, the employment-based green card process. It means that there are some things you have to consider and that you have to be careful of in terms of timing and strategy, but it is possible to pursue permanent residence even if your visa classification is not dual intent. As I said, you have to have some additional considerations and be careful about it. So let's talk first about what visa classifications are dual intent. First of all, when I say temporary visa classifications, I'm talking about non-immigrant visa classifications, which are the letter visas, right? So the H's, the L's, the TNs, the R's, that kind of thing, they are temporary in the sense that they're not permanent. They're not for a green card. They don't necessarily lead to a green card. But then there's a limited time duration, but that time duration can be years. So for example, a person can hold H-1B status for up to 6 years total, and you can extend beyond that in certain circumstances if you need to. So when I say temporary, I'm not talking about just a 6-month stint, but I am talking about these shorter to medium term visa classifications that are not permanent. So the visa classifications that allow for dual intent are specifically the H-1B and the L visas and the O-1 visa. All of those are dual intent, and they allow a person to remain in the United States and pursue permanent residence at the same time. More specifically, with the H-1B visa classification and the L-1 visa classifications, a person can hold those visa classifications and travel outside of the United States, even if they have the I-485, the application for permanent residence, or the application for adjustment of status pending. So again, even if they have the I-45 pending, they can leave the United States and re-enter as long as they meet certain requirements, right? You have to have a way to re-enter the United States. So that means you have to have a valid visa to re-enter the United States, or you have to have an approved advance parole. But the reason I'm saying this, the reason I'm differentiating these particular classifications is because there's guidance out there that says that you can leave the United States and re-enter on one of those valid visas as long as even though the I-485 is pending. So you have to be maintaining status and have a valid petition and all of that. There's certain requirements that have to be met. But my point is, even if you don't have an approved advance parole document, you can leave without abandoning the I-485. So if you hold H-1B or L, and if you're lucky enough have an I-485 pending with USCIS, know that you have more flexibility in travel than you would if you have another visa classification. Again, make sure that you talk with your immigration lawyer before you travel. You want to make sure that you have a clear way to come back into the United States, but that's really nice that you have not abandoned the I-485 if you travel, even if you don't have that advanced parole approved. Other visa classifications that are not dual intent. So we talked about the ones that are. The ones that are H-1B and L and O. The other visa classifications that are not dual intent basically are every other visa classification. But the ones that our clients use frequently are the H-1B1, which is for citizens of Chile and Singapore, the TN for citizens of Canada and Mexico, the any of the E classifications, so the E3, the E1, E2 visa classifications, the TN, I mentioned the TN. There are others as well, but those are the ones that our clients frequently use that are not necessarily dual intent. They're not dual intent. But like I said a few minutes ago, that does not mean that you absolutely can't pursue permanent residence in the United States ever. It means that you have to make some additional considerations if you are pursuing permanent residence and you hold those visa classifications. So what is it that you want to be aware of? And again, this is not legal advice, but these are just things to be aware of, talking points, things that you should make sure that you talk through well with your immigration attorney and make sure that you have a clear understanding before you proceed with this plan. So one thing, I mentioned this a minute ago, is that with the I-485, actually, let me make another point before that. With these visa classifications, a lot of times, not always, but a lot of times, if you are on one of these visa classifications that is not dual intent and you select the option of consular processing instead of filing the adjustment of status. And when I say you select, I mean on the I-140 petition, there is space to indicate series of boxes to indicate whether you plan to pursue filing an adjustment of status in the United States or whether you plan to pursue consular processing. So sometimes as a strategy, if a person is here, for example, on E2, for example, that's not a dual intent visa, then and they're going through the green card process, we will select on the I-140 petition that they're going to pursue consular processing, not the I-485. That means that they are not saying that the person, the beneficiary, they're not saying that they're going to stay in the United States and apply for a green card, but that they're going to apply for a green card at the US consulate overseas. That's one strategy that we have successfully used before. Again, it's not appropriate for every situation, so make sure that you talk to your immigration attorney to come up with a clear plan for you specifically. But that can be a way to address the situation or this kind of challenge for situations where the foreign national is in a visa classification that is not dual intent. So other things that you want to consider. If you are in a visa classification that is not dual intent and you have filed the I-485, know that if you leave the United States without that valid advanced parole document, then you will likely, USCIS will likely deem that you have abandoned the I-485 and deny it. So again, if you're not in H or L, you have to make sure that you have an advanced parole document approved to be able to re-enter the United States. If you have filed, like I said, the I-485 and you have the H or L, you have a lot more flexibility there and you can travel on the valid H or L as long as certain requirements are met. If you have an I-140 petition pending or approved and you need to either extend your status in the United States or renew your visa outside of the United States, and if you're in this visa classification that is not dual intent, make sure that you talk to your immigration attorney about what that process is going to look like, what the strategy is. You may need to make clear that you don't plan to apply for adjustment of status here in the United States. But you want to make sure that you're not going to have unexpected hiccups when you go to extend your status or renew your visa outside of the United States. So the key takeaways, like I said, that I want you to take away from this are: one, know what dual intent is. Again, it refers to this idea that there are some visa classifications that allow you to have two intentions at the same time that seem like they're conflicting. The intention of holding the temporary visa classification, the H or the L, and pursuing permanent residence at the same time. The second takeaway is only some visa classifications are dual intent, namely the H-1B, the L, and potentially the O. It's not quite as clear cut, but there is guidance in the Foreign Affairs Manual that says that it is dual intent. So know that not every visa classification is dual intent. And if you're not holding one of those visa classifications, that it doesn't mean you cannot apply for permanent residence. It doesn't mean that you can't start the employment-based or family-based green card process. But know that there are going to be some additional considerations that you need to keep in mind, some additional strategic plans that you need to have in place to make sure that you will be able to continue working, that you will be able to travel as and when you need to, and that you are not endangering the extension or renewal of your status or your visa classification. So, like I said, it's a nuanced thing. It's a nuanced matter, and it's something that we advise our clients on all the time. If they are in a visa classification that is not dual intent, we come up with short-term, medium-term, and long-term plans. Medium-term and long-term plans sometimes change, right? Because policies change or a person's situation changes or whatever it is. But it's really important to us that we have that conversation with the client to talk about what are their goals, what are their needs, what do they foresee coming up in the future, and come up with a strategic plan based on that and based on their immigration status. That's critically important. So I hope that you found this information helpful. If you did, I hope you will share this video with a friend or a colleague. And make sure to catch us next week for our next Live at Lunch. That's Tuesday at noon right here. Make sure that you are subscribed to this channel and this platform, whether you're watching it on YouTube, Facebook, or Instagram, so you don't miss our next video. Until next time, my name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world with family-based and employment-based immigration matters. See you next week.